This is not the official start. We did promise you 2 reasoning with Mr. Orette Bruce Golding. And we're looking at the reform of the Jamaican constitution and delinking from the British monarchy. So let me just say that I've had Mr. Golden sitting. He has reminded me that I have an hourly rate to pay. So I will bear that in mind. All right, so seriously now though, today we continue in this series presented here at the Mona, and we're looking at a number of issues that are germane to our constitutional arrangements and arrangements which have general implications for our development journey as a country. And we are fortunate to have had, as we have been in this series so far, persons who are able to bring very intimate knowledge to where we have been and what we have been about. So today, the formal welcome to the campus will be delivered by Principal Williams and Pro Vice Chancellor Williams, who is sitting here with us. But I'm really welcoming you really with my own greetings and call to order of the program here to the event and to the series for Principal Williams to do other things thereafter. But we want to thank persons for being here, and in particular, let me indicate that we have with us Sir Kenneth Hall, I'm seeing, former Governor General, with us, and he's somewhere, he normally sits somewhere in that little area around there. And he's sitting where he normally does, but he's with us, as he normally is. We have with us as well His Excellency, Ambassador Jan Henrik van Thiel, from the Embassy of the Federal Republic of Germany. He's here with us. We also have a number of confirmations that we have received. We see some honorary councillor and other persons. We see Minister Marlene Malahoo Fort with us as well, who is the Minister responsible for Legal and Constitutional Affairs, very instrumental in the context of what we're looking at, that she has made the time to be here and to also have members of her staff here with her as well. We have the Principal, as I mentioned, Denzel Williams with us. We have Attorney General Derek McCoy with us, Dr. Derek McCoy with us. We have a number of other persons who I don't have the list. Yes, indeed. We have members of the CRC, we have former deans, we have, in fact, former minister, Reverend Deacon Ronald Thwaites here with us as well. And he normally supports these events. Normally he's here for the ones we have. And we see a number of other persons, including Mr. Hugh Small, former Minister of Finance here, and in fact, member of the judiciary as well, former member of the judiciary elsewhere too, and a number of everyone else. We welcome you. Ms. Marcia Robinson, Dean at the faculty at UTech, is here with us. And we welcome you all here, expecting that we will have a very engaging session today. And it will be about you as much as it is about Mr. Golden. He will make himself available to speak to us, to give his own experience from his own journey, and will give you an opportunity to ask questions of him, which he, in his own style, will answer. He never ducks from questions, so I can assure you that he will do no different today, and he will answer the questions that are presented. So again, thank you for being here. And at this time, I invite Professor Denzel Williams, Pro Vice Chancellor and Principal here at the Mona, to formally welcome you to the University of the West Indies and to this event. Thank you.
Thank you very much, Dean Malcolm, and to my very erstwhile colleagues. Today when I looked at the program and I saw Riesling, Mr. Orette Bruce Golding, it reminded me of the Lord's Day. And those of you who don't know what the Lord's Day is, Reverend, I will give a quick synopsis. But it's a very special day at Lord's in England. As you know, in the West Indies, we play a sport called cricket. And we had one of the most prolific cricket players named George Headley. But as a Caribbean man, he would really have a great relationship with the spirits. And so he went out on the Lord's Day, had too much of the spirits, and after the first ball was bowled, he was out LBW at Lord's to a massive crowd. And the bowler went up to the umpire and said, "Umpire, Headley's out." He said, "Continue with the game." And he continued with the game, and at the end of the Lord's Day, he went back to the umpire and said, "Umpire, do you know Headley was out?" The umpire said, "Yes, I know he was out, but the people didn't come to see you bowl, they came to see him bat." So today, I know the people didn't come to hear welcome, they came to hear Mr. Orette Bruce Golding reason. And as a result of that, I will be very short in my welcoming you to our distinguished Mona campus. So, colleagues and friends, let me take this opportunity. Our chairman has done a really good job in identifying all of the special guests, etc. But it would be remiss of me not to recognize especially our former principal and governor general, Sir Kenneth Hall. He's normally somewhere in the front, but I don't know where he is today. But I know he's here. Sir Kenneth, welcome, and also to our honorable minister, our learned attorney general, also to our distinguished members of the CRC, the ladies and gentlemen of the clergy, also our distinguished speaker, former Prime Minister Golding, our Attorney General, my distinguished colleagues here at the UWI, our registrar, Ms. Israel, our advisor to the Vice Chancellor as well, and your boss is not here. Today we send apologies for him. Members from the Diplomatic Corps, and all other very distinguished members. It's indeed a pleasure to welcome you to our Mona campus this afternoon. But I want to just make a few quick remarks because I know Mr. Golding has something very important to tell us. But why I'm so proud and pleased about this engagement today and for the campus to be associated with the Reasoning series, because what it has done, or this series is doing, is to continue to position the campus to show the value that the university is bringing to the community. Those of you who are familiar and follow the happenings on our campus, you will know that for a long time we've had issues to do with our financial challenges, etc. But that has not really defined us as a campus, and we ought to be careful that we don't make the mistake that the campus is defined only by the financial issues that face us. Last year at this time, we would have amassed a deficit of about $1.7 billion in terms of our financial affairs. I'm pleased to report that at this time this year, we have turned around that deficit. We're now generating a surplus of $350 million. But I'm happy that you applaud, but I wanted to just say that's really not why we're happy as a campus, because that is just a part of what we do in order to keep our financials and our administration. But the most important part is our core business of teaching, learning, and research. And we're very pleased to note that the research activities on the campus, our advocacy, our pedagogy, and all of those kinds of things is now seeing a new turn. Like our reasoning series today, there are important value that we're adding as a campus to the community. I'm happy to report that over the past 2 years or so, this campus, the Mona campus, has researchers who have developed the first black cell line to treat with prostate cancer in the world. There is no other place in the world that you could now go and get treatment for prostate cancer in black people. Similarly, it is this campus that is now working on Psychosocial mushroom to help people with all kinds of mental illnesses. There is no other place in the world that you are getting that kind of research coming from. Similarly, it is this campus through the Solutions for Developing Countries, SADECO, that is working on malnutrition and brain development in children, to the point where the model is now being used in Asia, in Africa, and across the Caribbean to treat people with malnutrition. These are value-added things that our campus is bringing to the community. And today, we are bringing more value by having our distinguished speaker, Mr. Bruce Golding, adding to the discourse about our constitutional arrangement. This is really what our university is about. It is beyond financing, it is beyond the challenges of finance, and it is really about adding value to the things that will make our lives better. So today, Dean Malcolm, I'm very pleased and proud that our Faculty of Law is hosting this reasoning series. I'm very pleased that Prime Minister Golding has agreed to come to share and impart his knowledge with us. 52 years of contribution to nation building, Mr. Golding, is not something that is effortless and is not something you scoff at. It is indeed important knowledge and experience that you can share with us. And we hope that we will take the learning from today to better shape our societies tomorrow. So ladies and gentlemen, again, thank you very much for being with us this evening. Thank you very much to Prime Minister Golding for agreeing to come and impart knowledge, and we look forward to the conversation. But more importantly, we look forward to the lessons to be learned that he can better our society tomorrow. Thank you.
Thank you, Principal Williams, for the warm welcome and the added remarks that we're all happy to hear. Now, the person you came to hear on the Lord's Day is Mr. Golding. And the one thing that we need to remember on this campus at this time, above all else, is that he's a proud graduate of this very campus of the University of the West Indies. Now, Mr. Golding has had I like to think from reading about Mr. Golding that he was born into politics and for politics. But that has not defined him. What has defined him is the fact that he is selfless with his knowledge about us as a people, selfless in the contributions that he has made and continues to make in this country. And for those of us who have had the pleasure of speaking closely enough with him, we understand that he is a treasure trove of knowledge which you can hardly find anywhere else, certainly not in this country. And I like to say, and I know that he will tell us that perhaps he was born to be a lawyer, but there are few persons I know, certainly non-lawyers, who are better able to engage about the law than Mr. Golding. He knows it very well, he understands how it works, and he's able to speak very well on it. And that, in fact, is part of the reason why he's as able as he is to speak as well as he does about the Constitution and related matters, and the reform and related elements around that as well. And so today we're going to hear from him. He sent, when I asked him for something, for introduction, as he would do, he sends about 2 lines and say, this is what you're to say about me, not much. And so today I'm not going to go much beyond that, except to say that Mr. Golding is perhaps one, if not few, of the only living persons who were elected to the House of Representatives in the class of 1972. And he remains with us and has had a very long and distinguished career there. He served in the Senate. He was elected as a young person to the House. And he has led many ministries, several ministries, been, of course, a prime minister in Jamaica, and has been lauded in many respects. And history, as always, will judge us by the contributions that we've made, taken as a whole and in the round. And I think Mr. Golding, when he's looked at in that light, we will all see the significant value that he has made to us. Today, we are proud and happy to have him. And without saying more, I now invite Mr. Golding to do what he's here to do for us today, to make his presentation. Thank you.
Thank you very much, Chris. Good afternoon, everyone. And I want to say thanks to the Norman Manley Law School and Principal Denzel Williams for the kind invitation to be here and for the opportunity that has been offered me to share some observations on this important topic. Let's start at the beginning, when the Constitution was formulated. The criticism has been made that the process was rushed. It was done behind closed doors. The ordinary people of Jamaica were not engaged. Let us recall that the referendum which mandated the move to independence was held on the 19th of September in 1961. 1 month later, a joint select committee of Parliament was established to draft the new Constitution. That committee held 12 meetings, all behind closed doors. The minutes of those meetings were never made public. Public submissions were invited, but initially the public was given only 14 days to make their submission. That was later extended to 30 days. But there was hardly any public education to help the public to understand what all of this was about. And by mid-January of 1962, a mere 3 months after the process started, the Constitution was drafted, and it was approved by the Parliament of Jamaica. So that the criticisms that have been made about that process are valid. Although, I must point out that the criticisms ignore the fact that prior to that, starting in 1957, we had moved towards self-government, where essentially the British government was only responsible for external affairs and defense. And that new arrangement had in fact been consummated in the Constitution, Jamaica, what's it called? The Jamaica Constitution Order in Council of 1959. And many of the provisions in the new Constitution were lifted out of that 1957-59 arrangement, virtually word for word. But notwithstanding that, it was rushed. But you know, when I reflected on the last 60 years, 62 years of working under this Constitution, I am one of those who will argue that it has served us well. Not perfectly well, but at times during that 62-year period, when it has been tested, whether in the courts or on the streets, and sometimes sorely tested, it is an anchor that has held. And that is more than can be said for some former British colonies that have gone the same journey that we have. Are there deficiencies? Are there flaws? Certainly. And the fact that we have dithered for so long without rectifying them is something that I find disheartening. Part of the trouble, but what the late Congressman John Lewis would have called good trouble, is the way in which the Constitution was secured. Though it is not specified, and I remember Mr. Patterson when he was here the last time, made reference to it. Though it's not specified in the Constitution, our constitutional arrangements are predicated on a two-party system that produces a parliament with a unified government and a unified opposition. And the procedure for any significant change in the Constitution requires consensus, agreement between that unified government and the unified opposition. There are 138 sections in the Constitution. 58 of those cannot be changed unless there is agreement between the government and the opposition. Another 37 parts of other sections cannot be changed unless there is agreement between the government and the opposition. And the framers of our Constitution nailed it down that the government's complement in the Senate fell just short of the two-thirds majority that would be required to effect those changes. So that in practical terms, if the Constitution is to be changed, the government and the opposition have to find agreement. And you know, the framers of our Constitution were of the view that there were some sections of the Constitution that were so fundamental to the preservation and the good order of the nation state that they laid it down that even if there is agreement between the government and the opposition, certain provisions cannot be changed unless those changes are approved by the people. So what the framers did was that they cut three keys. They gave the government one key, they gave the opposition another key, and they said to the people, you hold this key. Because if they want to change certain provisions that we have put in here, they must not be able to change them unless they come to you and get your approval. And even where it involves agreement between the government and opposition, if there is disagreement between them and the matter is put to the people, it requires not just a simple majority of 50% plus one, but in some cases a 60% majority, and in a few cases a 66 2/3 majority by the people before those changes can be approved. Talk about belts and braces. This is chains and shackles. That's what our framers laid down. So the need for consensus is critical. I'm going to refer to that several times before I sit down. The only way the Constitution could be unilaterally changed is by the use of force. And thankfully, that is an inclination that has never surfaced in Jamaica. So the fundamental reality is that political consensus has to define, it has to inform any effort at major constitutional reform. Now, recently some persons took umbrage at a public comment I made that unless consensus is earnestly and genuinely sought and achieved, any effort at constitutional reform is a colossal waste of time. And some people took umbrage to that. As offensive as it might be, or as offensive as some may have found it, that is the stark reality. is so it's set. And there's no way we can get around that. That consensus is not easy to come by, given the adversarial nature of our politics. The government and the opposition, the two major parties, like chickens bred for cockfight, are instinctively combative, even when there is not much to combat about. But perhaps we shouldn't feel too badly. Look at the United States, which is worse than us. Look at the United Kingdom. Look at France. Time and time again, in our efforts at constitutional reform, that consensus has proven to be elusive. How we seek to broker that consensus is as important as the consensus itself. And I'm going to come back to that later. Our adventure into constitutional review and reform is not new. The first effort was made in the mid-1970s during the Michael Manley administration. When you look back at it, it was doomed to fail. If consensus is a sine qua non for any constitutional reform, the environment at that time was decidedly hostile. It was the most politically polarized period in our history. Consensus cannot thrive, cannot even germinate in that kind of soil. A public education program was launched. I remember my late friend D.K. Duncan was very much in the front of that. A rigorous campaign was waged across the island, but it took the form of political rallies dominated by people clad in a particular color shirt. It was like one hand uselessly trying to clap, and it withered on the vine. The second effort was made in the 1990s during the P.J. Patterson administration. It was a broader, more inclusive, more consensus-seeking approach. A constitutional reform commission was established, initially chaired by the late Justice James Carr and subsequently by Dr. Lloyd Barnett. But let me just pause here to illustrate the importance of a consensus-seeking approach. That 1990s effort didn't start with the Constitutional Reform Commission. It started with a joint select committee appointed in Parliament. And at the very first meeting of that committee, Mr. Edward Seaga, who was then leader of the opposition, argued strenuously and, as it turned out, persuasively. He said, this is not the approach we should take. We here in Parliament, cloistered as we are, shouldn't arrogate to ourselves the exclusive authority to reshape the Constitution. We need to consult the people. We need to get the views of the various stakeholders out there. And he proposed a constituent assembly. Now, the government of the time could have said, well, we have the majority and we're not into no constituent assembly. They didn't. They took Mr. Seaga's suggestion very seriously. And by the second meeting, they decided virtually to collapse the committee and to recommend to Parliament that Parliament establish a Constitutional Reform Commission. That was how the commission came into being, chaired by Justice James Carr and subsequently by Dr. Lloyd Barnett. I cannot stress enough how important it is for this matter to be approached with a willingness to compromise and to arrive at consensus. Because that's how that Constitutional Reform Commission of the 1990s came about. And that commission made a concerted effort to elicit public participation. Public submissions were invited and repeatedly encouraged. Town hall meetings were held in every parish. And that commission eventually submitted its report to Parliament, as a result of which another Joint Select Committee was established to consider its report, and I was privileged to have been a member of that committee. The report of the Joint Select Committee, which was submitted in 1995, set out the areas of agreement that had been reached, set out the areas of disagreement, the issues on which they deliberated but could not reach agreement. And all of this was following the consensus route. Let us see where we can arrive at consensus, and where we're not able to arrive at consensus, let us tell Parliament what are the differences that we have come up against. I think that that effort of the 1990s is arguably the most successful effort to date at constitutional reform in terms of the procedures that were adopted and the areas of agreement that were arrived at. And you know, it wasn't easy. I was a member of that committee. It wasn't plain sailing. We had contentious deliberations. We argued and we quarreled. We laid down non-negotiable positions that we subsequently found we had to be willing to negotiate. And, you know, as elusive as consensus can be, it is not beyond us. One of the things that helped that committee, that Joint Select Committee of 1995, was the presence on that committee of Edward Seaga and David Core. They were the two surviving members of that 1962 committee that drafted the Constitution. And when we argued at Gordon House and we got vexed and sometimes cuss off one another, those two went somewhere, sat down quietly, had a cup of tea, maybe a red stripe, and they were able to work through those difficulties and come back to us and say, look, as your elder statesmen, we have considered this issue and we are proposing that we proceed on this basis. I don't think that we could have achieved as much success as we did were it not for the involvement of those two. You know, when Mr. Pattison was here the last time, he made reference, talking about this business of consensus, he made reference to the establishment of the Electoral Advisory Committee in 1979. At the height of some bitter political exchanges. And he spoke about the role that he himself and Hugh Shearer played in bringing that about. And I myself and Paul Robertson, who was then General Secretary of the PNP, at a lower level in putting that together. And in both sides going to Michael Manley and Edward Seaga and said, you know, we think we have a deal. Now, Michael Manley and Edward Seaga were not just bitter rivals, they were arch enemies. I can tell you, I was there. And yet it was possible for them to find consensus. I sent a photograph up here. Can you put it on the screen? Because I think it would illustrate the point that I'm trying to make. That is consensus being formalized at King's House in the presence of the Governor General. If you look in the background, you will see Portia. And you will see K.D. Knight. And there is the Governor General Secretary, and there is Neville Lewis, the late Neville Lewis. And there is PJ and myself. That was consensus brought about despite the hostility between Seaga and Manley. So it is not beyond us. It's not beyond us. One advantage that that Joint Select Committee had and benefited from was the work of the Constitutional Reform Commission that preceded it. It was broad-based. It had 32 members drawn from political parties, academia, churches, legal fraternity, youth organizations, you name it. 32 members. And we benefited from the work that broad-based body did. Now let me just run through very quickly the issues on which agreement was reached. Firstly, there was to be a new Charter of Fundamental Rights which would not only expand the basic rights and freedoms to which every citizen would be entitled, but most importantly, it would remove the power that the government then had by simply passing a bill in Parliament to restrict those rights and freedoms if in its own exclusive discretion it thought it was necessary, and I want to quote the words from the old Constitution, if it thought it was necessary in the interest of defense, public safety, public order, public morality, whatever that was supposed to mean, or public health. So the Constitution, as it then was, laboriously specified the right to which every citizen is entitled. But in every instance, with the exception of the right to life, it carried a proviso that if the government in its own discretion and supported by its majority in Parliament thought it was necessary, it could suspend those rights for up to 1 year at a time. And when the year expired, could extend it further for another year. Now, there must be a place in the Constitution for the use of extraordinary powers for the protection of the state and its people, you know, in the event that the country is attacked by a foreign power, or if there's an attempt to remove the government by unlawful means, or in the case of natural disasters. What the new charter recommended was that such a power would be limited, such a power to invoke extraordinary powers would be limited to 14 days unless approved by Parliament with a 2/3 majority, which means that there would have to be consensus. Come back to this business about consensus between government and opposition. And we have seen that play out in Parliament, where the government has invoked state of emergency, and at the end of 14 days, when they got to Parliament, the opposition said, well, we're not agreeing for it to be extended. Importantly, in regard to the Charter of Fundamental Rights. The recommendation would make any such action by the government in terms of suspending people's rights justiciable, which means that any citizen of Jamaica can go to court and challenge the use of extraordinary powers. And if they do so, the onus is on the government, not the litigant, on the government to demonstrate that the action that it has taken, I want to quote from what is in the new Charter of Rights, the action that it has taken was demonstrably justified in a free and democratic society. So you have to satisfy the court. You don't have that final say. And the court can, as it has, in one particular instance, says no, we're not supporting it. Now, much of the constitutional reform discussion, has centered around removing the Queen or the King. What is my take? This question of securing the fundamental rights of our citizens is the most consequential recommendation that came out of the 1995 Commission and Committee. In my view, far more important than getting rid of the Queen, as important as that is, but securing the rights of our people. And I have watched, over the last 10 years, I've watched and seen how many occasions that our courts have interpreted that provision in defense of the rights of our citizens. Now, secondly, in terms of the issues on which agreement was reached, Jamaica would transition to Republican status, replacing the Queen as head of state with a president, who, although essentially non-executive, would exercise certain quasi-executive powers, as was then and continues to be the case with the Governor General. Thirdly, membership of the Senate would be expanded from 21 to 36, with the Prime Minister and the Leader of the Opposition nominating 20 and 14 members each. There were to be 2 other appointees who would complete the membership of the Senate. And that was designed to preserve the delicate balance in which a number of government members would fall short of the 2/3 required to alter any significant provision in the Constitution. Fourthly, appointments to certain critical positions would be made by the head of state, the president, after consultation with, but not necessarily on the advice of the Prime Minister and the Leader of the Opposition. And the positions to which those arrangements would apply are the Chief Justice, the President of the Court of Appeal, the appointed members of the Judicial Service Commission, the members of the Police Service Commission, the Public Defender, and the Contractor General, and also the independent members of the Electoral Commission. There would be entrenched provisions in the Constitution for the impeachment of public officials. I'm going to come back to that. Only citizens of Jamaica would be eligible to sit in Parliament. The committee didn't get into the business of dual citizenship, but it certainly felt that no Commonwealth citizen who is not a citizen of Jamaica ought to be eligible for Parliament. The power of the Prime Minister to call general elections at any time would be subject to the existence of a voters list that had been updated within the previous 6 months. Provision would be made for a Citizens Protection Bureau headed by the Public Defender to assist ordinary citizens in the protection of their constitutional rights. Limits would be placed on the number of parliamentarians that can be appointed to ministerial positions. The Constitution would reaffirm the right of the Chief Justice to sit in the Court of Appeal instead of the current arrangement where he can do so only on the invitation of the president of that court. Provision would be made to enable individuals, and this is important, provision would be made for individuals and organizations to challenge on public interest grounds actions of the government without having to obtain the consent of the Attorney General, and to widen locus standi to facilitate class action suits. There would be express provision in the Constitution for decisions of the Director of Public Prosecutions to be subject to judicial review, and provisions relating to the Electoral Commission, Contractors General, Citizens Protection Bureau would be entrenched in the Constitution. Those are the areas on which agreement was reached. But there were areas of disagreement, and the committee in its report detailed those areas. One was, while it was agreed that the president as head of state would be nominated by the prime minister after consultation with the leader of the opposition, but would be subject to confirmation by a two-thirds majority of parliament voting by secret ballot, there was disagreement as to how that two-thirds majority was to be counted. The then government, PNP, argued that it should be with both houses sitting together, and then you get a two-thirds. The then opposition, JLP, argued no, it should be both houses voting separately to ensure that that critical two-thirds safeguard in the Senate does not allow the government to have its way. We have a situation now, for example, where if it was the two houses sitting together with the overwhelming JLP majority in Parliament, then the government would have a two-thirds majority of any such joint sitting. Secondly, in terms of areas of disagreement, with regard to the 2 additional seats in the Senate, the then PNP government wanted those seats reserved for third parties who had registered at least 7.5% support in the previous elections, failing which then they would revert to appointment in the normal way, one by the Prime Minister, one by the leader of the opposition. The JLP opposition at the time argued that no, those 2 seats should be reserved for some independent voices, so let those 2 persons be named by the president in his own discretion to introduce some diversity to this Senate. In terms of issues on which there was not full agreement, while it was agreed that appointments to certain critical positions would be made by the head of state after consultation with, but not necessarily on the advice of the Prime Minister and the leader of the opposition, there was disagreement as to the role of Parliament in relation to those appointments. The then JLP opposition insisted that those should be subject to the two-thirds rule in both houses of Parliament. The then PNP government argued no, those appointments should be made and only subject to a negative resolution by two-thirds majority coming from the Parliament. Now, what became of the areas of agreement that were reached in 1995? That's almost 30 years ago. And what has been done to iron out the areas of disagreement, which were largely procedural, although procedurally significant. And you know, like in so many of our undertakings as a country, constitutional reform has suffered an implementation deficit. We were able to enact the new Charter of Rights in 2010, which, as I said before, I consider to be the most consequential of the amendments that were proposed. And it was a major achievement. I remember a man said to me once when we ran into him at a hardware store and we were talking about constitutional reform, he seemed quite interested in the matter, but seemed to have had little interest in removing the Queen. He said to me, the Queen don't trouble me, so we may trouble her. And I suspect that that's not a view that is confined to him alone. But we were able, in 2010, based on a bill that I took to Parliament, we were able to enact an amendment to the Constitution for the introduction of the new Charter of Rights. How? Because of consensus. The initial position taken by the PNP was that they're not going to agree to that unless we agree to the removal of the Privy Council and the accession to the CCJ. We talked about it. I remember saying to Portia, I said, Portia, don't make her go on a political platform and tell her that you have stood in the way of people's rights being secured. And she laughed at me. But we continued to talk until eventually, after we prepared the bill, in the House one day, I asked her to meet me behind the Speaker's chair. And I said, Portia, I want to bring the bill next week, but I cannot bring it unless you are prepared to support it. And she squeezed my hand and said, bring the bill. And that is how the Charter of Rights managed to be enacted. As I say, perhaps the most consequential part of the proposal. The other issues on which we agreed have languished for 30 years. Where are we today? The new Constitutional Reform Commission has submitted its report. The process that it used, let me just say a word about that. There are alternative process approaches that could have been taken. One would have been to simply go through the 1995 report and check the boxes. I said, do we still agree on this? Tick that one and move on. Do we agree on this? Tick that one and let's move on. Alternatively, it could have decided to revisit those issues, updating them based on the passage of time and the fact that new thinking may have emerged. But of course, running the risk, the hazard of unagreeing things that had previously been agreed. When I looked at the terms of reference, it appears to have sought to do both. It speaks of building on the work of the 1995 report, but also to review based on the passage of time. So, for example, the question of eligibility to Parliament being confined to citizens of Jamaica, that was checked because we had dealt with that in 1995. Public defender, checked. Parliamentary versus a presidential system, that was an issue that was settled in 1995. But the new committee revisited that issue and it checked it. So there's no presidential arrangement, parliamentary system. Impeachment provisions, that was revisited, that was agreed in 1995. That was revisited and excised. I viewed that with some dismay. It was an issue that was heavily canvassed back in 1995. It was part of the JLP manifesto of 2007. Indeed, I tabled a bill in Parliament in 2011 to give effect to impeachment provisions. In the JLP manifesto of 2011, it was listed as a work in progress. It was not included in, it was not mentioned in the JLP Manifesto of 2016, but in the JLP Manifesto of 2020, it is one of several issues on which there would have been wide-scale consultations, quote unquote, with the Jamaican people. The PNP signaled its support for impeachment because the leader of the opposition brought private members' motions or bills to Parliament to give effect to impeachment provisions. And therefore, I'm still trying to understand. If the JLP was committed to it, and the PNP is committed to it, but in the committee where they both sat, they decided that it's not such a good idea. I'm wondering whether it is the non-JLP and non-PNP members of the committee who persuaded them that this is not something that ought to be proceeded with. And I haven't seen any minority report from the PNP to suggest that we disagree with this decision. Now, I look carefully at the reasons for the rejection of the idea. Firstly, the committee states that it is dealing with what is essentially a legal matter through a political process, as most impeachable offenses are criminal in nature and properly triable in the courts. And you know, I respectfully disagree. The proposals that were put forward in 1995 were not intended, although, and I'll come back to that quirk, were never conceived as a substitute for criminal prosecution. The Joint Select Committee of 1995 did include as a ground for impeachment corruption or misappropriation of public funds or property. So that would definitely fall within the concern that the new committee has expressed. Well, you know, if a potential conflict exists between impeachment and criminal proceedings, let's remove triable offenses from the definition of impeachable causes, rather than shredding the idea altogether. Because the 1995 recommendation went on to specify misconduct or malfeasance that renders someone unfit to hold office, not necessarily criminal in nature. You can have a public official who misconducts himself or herself in a particular way, but it's not a crime. But you certainly don't want that person continuing in public office. And hence, the 1995 recommendation also included misconduct so serious in nature as to render the holder of public office unfit to continue to hold that or any other office, or misconduct which brings the office into disrepute. And it further specified as grounds for impeachment refusal or persistent neglect in the exercise of the duties or responsibilities of a public office, abuse of statutory power or authority, deliberately misleading Parliament, or intentionally abusing the privileges of Parliament. As I've indicated, these are not necessarily offenses triable in a court, but the Select Committee of 1995 considered that they were sufficiently important and impactful to warrant removal from office. The second argument put forward by the recent commission is that the impeachment process can easily be manipulated for partisan political purposes. It is difficult to ensure an impartial hearing by members of a parliament that is divided along partisan lines. Now, I'm in sympathy with that concern. I find sympathy with that. You know, I have a deep disappointment that the political maturity that I thought was evolving, where partisan political interests could, in certain situations, could be subordinated to the national interests. I'm deeply disappointed that that evolution has not materialized. We are as tribalistic as we ever were. It's only that we no longer trade bullets, we trade insults. We are averse to finding common ground. But it is possible to insulate the impeachment procedure from partisan politics. Because while it is true that impeachment in most instances where those provisions exist, it's a legislative matter conducted within the legislature, it does not have to be. Indeed, the Joint Select Committee of 1995 had recommended a two-stage process. First, a recommendation to impeach coming from a parliamentary committee, and then a referral to an independent tribunal for a hearing to be conducted and for a decision to be made. Well, to respect the concern that the commission has expressed regarding the danger of partisan politicization, let us eliminate the parliamentary procedure. Let us eliminate that stage altogether. And let us define the requirements for an impeachment petition to exclude frivolous and vexatious abuse. And you know, the reason why I hold to this position quite strongly is that impeachment is not a new idea in our Constitution, you know. We have provisions in the current Constitution for the impeachment of judges of the Supreme Court, for the impeachment of the DPP, for impeachment of the Auditor General. It requires the establishment of a tribunal, which then hears evidence, listens to the arguments, and then makes a recommendation as to whether that person ought to be removed from office, so that it exists. And if it is good enough for our judges and good enough for our Auditor General and good enough for our Director of Public Prosecutions, why it is not good enough for certain other public officials? And then the Commission went on to point out that where the matter being investigated involves the allegation of a crime, then the normal criminal proceedings would be invoked, which creates the risk of competing and conflicting jurisdictions and outcomes. Well, I've already said, well, let's remove tribal offenses. In cases where impeachable offenses are not criminal offenses, the definitions are generally vague, and therefore the impeachment process is inconsistent with the principles of natural justice. Well, let us fix that. Let us remove the ambiguities without making the provisions inapplicable. I want to turn now briefly to the areas of disagreement coming from 1995, which the new commission, jointly chaired by Minister Malahou Fort, sought to resolve. One had to do with the enlargement of the Senate. The 1995 committee had proposed a Senate of 36. The new committee has proposed a Senate of 27. With 3 of those 27 being appointed by the President in his own discretion. I'm happy with that. I mean, I'm prepared to endorse that. The method of appointing the President. Now, in 1995, the problem that we ran up against was that the JLP was saying the president must be appointed subject to two-thirds majority in each House of Parliament, voting separately and secretly. The PNP at that time had said no, they must meet together, vote secretly, but you count the two-thirds jointly with the 63 MPs and the 21 senators voting together. The recent commission retained the recommendation that it must be a two-thirds majority vote in each house, but they insisted voting separately, which I endorsed. But then they went further. In anticipation of the inability of the Prime Minister and the Leader of the Opposition to agree on a nominee to be submitted to Parliament, they suggested that in that situation, it should be put to a vote in Parliament, each house voting separately, but this time not a two-thirds majority, a simple majority. Well, that troubles me. It troubles me because what then would induce a Prime Minister to try to reach consensus with the Leader of the Opposition? If that Prime Minister knows that if we can't reach agreement, then you put a name forward, I put a name forward, and the majority in each House of Parliament will decide. Well, I control the majority. So I'm not into no consensus with you. Because I know that ultimately if I hold out, then I will have my way. I understand the deadlock concern, you know. You have a situation where the Prime Minister and the Leader of the Opposition cannot agree on a nominee. The country is without a president. That's a deadlock that has to be resolved some way or the other. But you know, despite what I've said before, I have not given up on the hope that at that level, at the level of our two most senior political leaders, and in relation to so critical an issue as the appointment of a head of state, I have not given up on the hope that reasonableness can prevail. If Michael Manley and Edward Seaga can do it, anybody can do it. You hear what I tell you? All right? But we still have to make provisions in the case that reasonable men are inclined to be unreasonable. The Commission has already suggested that in the event of the absence of the President or the vacancy in the position of President, that for the time being, one of the custodies will act. And it is the custody who is chosen by the Prime Minister on the advice after consulting with the Leader of the Opposition. So essentially it's the Prime Minister's decision. I don't have a problem with that. But my suggestion is that if the vacancy in the office of the President exists for more than a specified period, say 60 days, then I don't believe that it is the custos chosen by the Prime Minister who should continue to occupy that position. In such a situation, I think we should give consideration to the Chief Justice acting in that position until such time as the Prime Minister and the Leader of the Opposition can reach agreement and go to Parliament and get the two-thirds approval. I'll be comfortable with that. There were some issues that were agreed in 1995 which were not addressed by the recent commission. One, the method of appointment, including the role of Parliament for certain critical positions. The Chief Justice, the President of the Court of Appeal, the Services Commission, the independent members of the Electoral Commission. I mention those, because that was included, Marlene, my friend, in the JLP manifesto over 3 election cycles. 3 election cycles that those would be included in the constitutional changes that we would seek to effect. Then there is a question of limiting the size of the executive, which the JLP had included in its manifesto of 2011 and 2016. Then there's the question of the relationship, the awkward relationship between the Chief Justice and the President of the Court of Appeal, which 1995 we had agreed had to be fixed. The issue of judicial review of the decisions of the Director of Public Prosecutions. Now, in that regard, I'm aware of a Privy Council decision made in 1994 on a case brought from Jamaica, and very recently, within the last couple of weeks, on a case brought from Trinidad and Tobago, in which the Privy Council had some pretty sharp comments to make about seeking to interfere with the autonomy of the Director of Public Prosecution. It was our view in the 1995 committee that as independent as the Director of Public Prosecution must be, the Director of Public Prosecution must also be held accountable. And therefore, the decisions, the actions of the DPP should be subject to judicial review. And as powerful as the Privy Council might be, the Privy Council is subservient to and has to abide by the provisions of our Constitution. Then there is the other issue which the recent Commission seemed to have overlooked, the right of individuals and organizations to challenge the actions of government on public interest grounds without having to get the Attorney General's consent, and redefining locus standi to allow for class action suits. That we considered then to be important. I consider it today to be just as important. There were some issues that the recent Commission took up which were not included in the deliberations of 1995, and I'm obliged to speak to some of them. One was the question of a fixed election date or a fixed election period, which would address the question of the power of a Prime Minister to call snap elections, no? And the Commission examined that. I had difficulty in understanding its recommendation. The Commission recommended that in the event there is consensus between the 2 political parties represented in Parliament, the life of the Parliament should be fixed at 5 years, with provision for the actual election date to be set by the Prime Minister on a day within a period not exceeding 3 months. I wasn't sure what that means. Currently, the life of Parliament is for a maximum of 5 years, but it comes to an end if an election is held before. The Commission says, in the event there is consensus between the 2 political parties represented in Parliament, the life of the Parliament should be fixed at 5 years. I've tried hard to see if I can interpret that, and I haven't been able to. The actual election date to be set by the Prime Minister on a day within a period not exceeding 3 months. I assume that that means 3 months before the 5 years, before the end of the 5-year period. And then when it speaks about consensus, I'm assuming that it means that if there is agreement between the government and opposition, then the 5-year period can be ignored. But I need some clarity on that. The question of term limits, that did not arise in 1995, but it was part of the JLP manifesto of 2011. And it was listed in the JLP manifesto of 2020 as one of the issues on which there would be widespread consultation with the public. That did not seem to have come up. The question of the removal of senators, and I want to spend just 3 or 4 minutes on this. The power of the Prime Minister or the Leader of the Opposition to effect the removal of a senator who was appointed based on their nomination. The issue did not arise in 1995. It has subsequently become an issue based on issues, things that have happened and court involvement. And the commission that Minister Mallow-Fort chaired, quite rightly, took up the issue. The committee referred to the Interpretation Act, which says that if you have the power to appoint, you also have the power to remove. But of course, that is a simple piece of legislation that doesn't apply to the Constitution. All of the research that I have seen suggests that back in 1962 and even before, when we had the Legislative Council, the intention was that it was to be a chamber of review where people bring, quote unquote, independent minds to issues. And hence, to ensure that they could exercise that independence, they were given security of tenure. You can't be fired, you have to resign. In reality, that is more imaginary than real. I have had the obligation of appointing senators. I certainly wasn't going to appoint no senator who I feel is going to tell me, well, having appointed me, I go about my business now, I don't business with you. And why do I say that? The court in that case that was dealt with by the court made it clear that neither the Prime Minister nor the Leader of the Opposition has the authority to effect the removal of senators, whether overtly or circuitously by undated letters of resignation. The commission, the recent commission, stated in its report that it could not arrive at any consensus as to whether any change ought to be made to the current arrangement. Well, I disagree. I believe changes need to be made. Why do I say that? The current arrangement, and this applies more to the Leader of the Opposition than it applies to the Prime Minister, but the current arrangement where the Leader of the Opposition can effect the appointment of 8 senators. And through those 8 senators, the opposition holds that critical balance in the Senate to ensure that the government cannot exert a 2/3 majority in the Senate to mess with the Constitution. This business where the Leader of the Opposition cannot effect the removal of a senator that he has nominated is in sharp conflict with the most critical safeguard that was built into the Constitution. And that is that the opposition holds that critical balance. Government can't get 2/3 unless you try and get some consensus with the opposition. And remember what I said? 51 of the 138 sections of the Constitution and 37 parts of other sections require opposition concurrence by at least one member in order to be changed. What happens, and hear me out, what happens if an opposition senator falls out with his party and decides to go rogue and decides to be spiteful and revengeful and says to the Leader of the Opposition who appointed him, You put me there, but watch me now. I'm going to fix your business. I'm talking with the government, and I'm telling them whatever constitutional amendment they want to bring it come, because my vote is ready. What happens if an opposition senator is induced by an offer that his circumstances and level of moral integrity makes it difficult for him to refuse? This critical safeguard that Norman Manley and Donald Sankster laid down in our Constitution to make sure that government can run amok over our Constitution, that critical safeguard lies in the hands of any of 8 members of the opposition. And therefore, if the leader of the opposition feels that he can no longer have confidence that that safeguard is intact, why should he not be able to write to the Governor General and say, Your Excellency, having examined the situation, I hereby recommend the revocation of the appointment of Mr. Bruce Golding as a senator, and I will subsequently advise you of a nomination for a replacement. That is what would enhance this critical safeguard in our Constitution. I'm worried about it because in these days in politics, anything can happen. And if our framers were so concerned to put in that safeguard, I don't believe that we should allow it to remain so exposed, so vulnerable. Beyond these gaps and the alterations proposed by the Constitutional Reform Commission, we are at a point where, sadly, the momentum towards constitutional reform has been disrupted by the issue of the Caribbean Court of Justice. That is the elephant in the room. The JLP has taken the position that, look, this matter is one that the people should be asked to decide. And you know, there's merit in that argument. I've heard some people kind of dismiss it out of hand. There's merit in that argument. If the question as to whether or not we have a king or we have a Jamaican president is important enough, if the question as to whether or not we have a parliament of 63 members or whether we should increase it to 72 members, if that is sufficiently important that that would require the people to vote and decide, then there's an argument that can be made. That, look, if you're talking about our final court, our apex court, the court from which all other courts would have to take guidance, then that is something that the people should decide as well. The PNP, on the other hand, have expressed serious concern about putting that matter to a referendum because of the danger of it being smothered by partisan politics with scant regard for the issue at stake. And there's merit in that argument too. Any occasion on which people are being called out to vote, the motivation to vote can either be whether my road fixed, I don't have no water, I don't have no light. When they go to the MP and beg him a work for my daughter, I may not get it. Look at money under the table. So that the issue as to what we want, the quality and the structure of our final court could be an issue that is not in the minds of people. So there's merit in that argument that the PNP has put forward. But in any event, you know, if the matter is put to a referendum, what guidance will the parties offer the voters? Almost certainly, the PNP is going to say to the voters, vote to get rid of the Privy Council and vote to accede to the CCJ. Well, what is the JLP going to say? Is the JLP going to say no? Don't do that? Or is the JLP going to say, well, we're not taking a position, we're going to leave it up to you? That's a quandary. Voters need guidance, no? And therefore, it's an issue on which positions need to be taken. So the business of constitutional reform is stuck unless we can arrive at some compromise regarding the CCJ. And the PNP strategy is very transparent, you know. The PNP is using that balance that it holds in the Senate as leverage. The PNP is saying that, look, if you want my vote to deal with these matters of constitutional reform, even though we agree with them, but if you want my vote on those matters, you have to give me the CCJ as well. As I said before, you know, it was an issue when we tried to get the Charter of Rights enacted. We were able to get over that. We were able to find a consensus that allowed us to proceed, even though the issue of CCJ remained an issue to be dealt with. I don't know if that luck, Marlene, that I had then can return. So let's face it, unless there's a change in the PNP position, there's going to be no constitutional reform until this issue of the Caribbean Court of Justice is dealt with. Now, I want to spend a few minutes on it, on that particular issue. You know, history can be quirky. As P.J. Patterson pointed out when he was here, it was in 1970 that the Commonwealth Caribbean Bar Association put together proposals for the establishment of a Caribbean Court of Appeal. That was in 1970. It was submitted to the CARICOM heads of government at a meeting in Kingston, chaired by Hugh Lawson Shearer, and it was adopted. Now, bear in mind that any decision made by CARICOM heads has to be unanimous. There is no provision in CARICOM for any majority decision. So whatever decision is made, all heads agree. And that meeting was chaired by Hugh Shearer, and the proposal was adopted. It was left to languish for, oh Lord, over 15 years. But in 1987, CARICOM heads of government took the decision to proceed with the implementation of a Caribbean Court of Appeal. That was when Mr. Seaga was Prime Minister. Mr. Seaga attended the CARICOM heads of government meeting at which that decision was taken. I remember I was a member of the cabinet at the time. The Attorney General then, Oswald Harding, was detailed and instructed by cabinet to work with his CARICOM fellow attorneys general to hammer out the details as to how the court was going to be established. Now that was 40, 50 years ago. The issue was discussed during the 1995 constitutional review. Not exhaustively, because this was 10 years before the CCJ was established. And hence, it wasn't a sticking point. I mean, we had the Privy Council then, we didn't have any CCJ, so it did not become a major issue of contention for the Commission, as it has subsequently become. Let me just quote from the report of the Joint Select Committee, paragraph 129. The committee also adopted the commission that the Justice Carr, Dr. Barnett Commission. The committee also adopted the Commission's recommendation that the present system of appeal to the Privy Council should continue, but stated that this arrangement is subject to the introduction of a Caribbean Court of Appeal if and when such a decision is taken. End of quote. Now, when the work to establish the CCJ was on in earnest, some disturbing issues arose. And this is where the game got coalted. Firstly, the initial proposal was that the judges of the court were going to be appointed by the heads of government of the Caribbean. And that kind of sent off alarm bells for a number of persons. Then secondly, the funding of the court would be dependent on annual budgetary subventions from Caribbean governments. Now, Professor Denzel Williams will tell you that that is not a very secure arrangement for the funding of anything. Sometimes CARICOM tell you, well, look, I know I'm 4 years in arrears, but things kind of tough, so hold on a little bit. And then there was this egregious episode in Port of Spain, where the then Prime Minister, Basde Opande, mounted a political platform and declared that the Chief Justice of Trinidad and Tobago was public enemy number one of his government. Now, that's hardly the kind of person you want to have appointing judges. There was a pushback against these arrangements. Pushback from the JLP opposition at the time, Bar Association, civil society. We said, no, this can't work. And in fairness, the heads of government went back to the drawing board, and they came up with a new arrangement that the judges would be appointed by a regional judicial service commission, which would be comprised primarily of members of the legal and academic communities. Secondly, that in appointing judges, the selection will be open to applications rather than handpicking people. Thirdly, that insofar as the funding is concerned, a trust fund would be established which would be intended to finance the court in perpetuity. And Jamaica contributed $25 million towards that trust fund. I should mention that the stability of that trust fund has been tested, because when we had the global financial crisis of 2008, it suffered some losses, but it was able to weather the storm, and it has recovered. And that trust fund is, the last time I looked at it, is in good shape, and it was able to recover without asking Caribbean governments for any additional contributions. But still, you know, in spite of all of that, some discomfort has lingered in several quarters. We have had referenda in Grenada, St. Vincent, Antigua, the Bahamas, no, not the Bahamas, Antigua, St. Vincent, Grenada, which included among the issues the removal of the Privy Council and the establishment, the accession to the CCJ. Now, in fairness, those referenda dealt with not just that issue, but other issues, including removal of the monarchy. And all of those were lost. People voted no. Some people are mistrustful. Let's face the facts. There are some people who are just mistrustful of anything Caribbean, anything regional. And there are others who just take a view that in relation to the Privy Council, if it ain't broke, don't fix it. What you're troubling it for. So in terms of advancing, and even within the political parties, there are persons in the JLP who, prefer to remain with the Privy Council. And at least one prominent member of the People's National Party has come out publicly and defended the retention of the Privy Council as our final court. So in terms of advancing the process of constitutional reform, this is the elephant in the room. And let me say this, because I think it's important. That elephant has grown fatter and more boisterous by the way in which the debate about it has been conducted. Remember, nothing can happen, nothing in terms of constitutional reform, nothing in terms of the CCJ, without consensus. When those who strongly advocate for the removal of the Privy Council and for the accession to the CCJ, when they portray those who are against it as backward, anti-nationalists, persons still trapped in mental slavery, I suggest that that is decidedly unhelpful. And when those who want to retain the Privy Council dismiss those who are in favor of the CCJ as persons who are trying to return to a federation through the back door, persons who are prepared to sacrifice the quality of justice for some intellectual obsession, I suggest too that that is decidedly unhelpful. This adversarial approach will never work. Neither side in that argument can browbeat the other side into submission. It has to be consensus, not coercion. The leader of the opposition, when he was Minister of Justice back in 2015, I think it was, he brought some bills to Parliament. I think it was 3 bills. In effect, to remove the Privy Council and to establish the CCJ as our final court. Now, I'm assuming that when he did that, it was intended simply to lay out his party's position. Couldn't have been done in the hope of securing consensus through parliamentary debate. That's not how you get consensus. That has never happened before. It is in the corridors, it is on the verandas. It is a quiet sitting down and talking one-on-one. That's how you get consensus. And when you get consensus, then you bring the bills, when you're assured that you have the support to secure passage. So let's have a discussion. Let's talk about it. But for God's sake, let us have that discussion with an appreciation and respect for contending views and the concerns of the other side. Now, let me just share with you my position on the CCJ. I've taken a structured approach. I shared those serious concerns initially when we were going to have a court appointed by the likes of Basdeo Pandya. I had serious concerns. I had serious concerns when it was initially proposed that, governments must cough up money each year for the court. I said, well, I don't know how long this court will survive. But those concerns were addressed and resolved. In 2005, Mr. Siaga took an interesting position. It was not an emphatic rejection of the CCJ. What he said in 2005 was, look, this court is brand new. We don't know how it's going to work. So let us watch it for 10 years. And at the end of 10 years, let us look at its procedures, let us look at its decisions, and then let us make an assessment as to whether or not we are comfortable to have that as our final court. That's what he said in 2005. That assessment has never been done. It's almost 20 years since then. And part of the problem we have with the discussion about the CCJ is the lack of critical assessment. There was a publication which the CCJ funded in 2015, a publication called, I think it was called Caribbean Court of Justice After 10 Years. And in that publication, Lloyd Barnett contributed one of the chapters. Try to get your hands on it, no? I would have thought that the CCJ would have made it available as an e-book where you can simply go online and read it, no? The CCJ website boasts plenty of resources, you know, reports, procedures, rules, publications, but try to access them. You click on something, you get a blank screen. I've tried it with different computers using different browsers, and it's impossible. If you go on the website for the Privy Council, you can get anything you want with the click of a button. And the CCJ better understand that, you know, in this race, in this debate, they have to step up. They have to enable us to go out there and argue, well, the CCJ is the way to go because of reasons 1, 2, 3. I say we lack critical assessment. Our legal community has been missing in action. What have they done, all our erudite lawyers? What assistance have they provided in giving us an appreciation of the Caribbean Court of Justice, its procedures, its accessibility, its timeliness in terms of handing down decisions, the quality of those decisions? Chris, what has Norman Manley Law School done? I mean, how many sessions like these has it put on?
I don't know, sir, but I know about the faculty of law.
To enable us to get a better understanding of the CCJ decisions, its reasoning, the extent to which it has broken new ground in jurisprudence, and give us an assessment of that new ground. My assessment, when I was here on a fellowship up to a couple of years ago, I took the opportunity in 2015 to read, I wouldn't say all, but most of the decisions that the court had handed down. Certainly the appellate decision. And I will tell you quite frankly, I was impressed. I was impressed at the reasoning that was offered. I was particularly impressed at the language that was used. I could understand it. But I'm not a legal scholar. So I'm not competent to determine whether or not this is good jurisprudence. We need our legal community to help us to understand it. But you know, in terms of my take, the issues of sovereignty which have been touted, well, you know, we must remove the last vestige of colonialism. We must get rid of the Privy Council. You know, that is not what moved me, you know. The question of ease of access. I would have a problem, for example, if I needed to take a case to the Privy Council and my lawyer told me that he applied to the UK Embassy High Commission and they turned down his application for a visa. I'd have a problem. The question of the legal fees that are involved, the airfare, the hotel accommodation, all of that. One of the issues that we need to address locally, you know, those who are advocating the CCJ, a lot of the cases that go to the Privy Council now for poor people are handled free of cost by British lawyers, or else some of those cases will never reach there. And every time I've asked, well, what comparative arrangement are we putting in place for the CCJ, because it is still expensive to go down to Port of Spain. And even if they come here, it is still expensive to get lawyers to appear before them. I'm told that, well, that can be done through legal aid. That's not good enough. We need to put in place a much more robust arrangement that people who cannot afford the heavy cost of legal representation can be assured that they would have access in the same way that them get free access to the Privy Council through pro bono lawyers. But you know what is my greatest concern? Availability. When Lord Phillips was Chief Justice, he basically said to us, leave the area. Now his successors have recanted that. His successors have said, no, you're welcome. You can stay as long as you want. But my problem is that this is not a judicial decision. It's not for the Privy Council to decide whether we can still go there. It's a political decision. It's a decision that is to be made by the British government and the British Parliament, because our access to the Privy Council is governed by the Judicial Committee Act of 1833. That's an act of Parliament. So that British parliamentarians could go to Westminster next week and amend that act to say that Privy Council cases will be subject to British dependencies and colonies and no longer available. And they could do that without any consultation with us. I am uncomfortable about the fact that the right of appeal to the Judicial Committee of the Privy Council, which is specified in our Constitution, is really not a right that our Constitution has the power to bestow. That the Constitution seeks to bestow that right, but it does so at the pleasure of the British Parliament. What would we do if at some point the politicians in Britain, who in recent times have shown an inclination to take some weird positions, upending decades and even centuries of tradition, what would happen if they decide now that they're going to change this Act of 1833? What do we do at that time? Run down to Port of Spain and say, boy, we're ready now, we come? Or scramble to see if we can set up our own court. I had appointed a committee back in 2011, I think it was Marlene, which you chaired, to look at this issue. And the committee suggested that one of the things that we should consider is setting up our own court, our own final court. And that is not an idea that should be rejected without consideration, but it does have some issues. The cost implication. Perhaps even more, maybe we can find the money, but one of the problems we'd run into is that we'll be trying to populate an apex court from the same small pool of talent that we have. So when you do that, you're doing that at the expense of the Supreme Court and the Appeal Court. And then there's the other issue of the limited jurisprudence to which you would be exposing yourself. One of the advantages of the Privy Council is that they deal with a much wider range of cases than the ones that just come from Jamaica. Same thing with the CCJ. If we have our own final court, then our jurisprudence is limited to what evolves here. So those are issues that would have to be taken into account. I've been going on too long. I want to wrap up. Just two final points. Much has been said about the level of public participation in the constitutional reform process. and the opportunities or the lack of opportunities for the public to become involved. In 1962, as I pointed out, no direct consultation, 30 days for public submissions, very little public education, 78 or 79 submissions received. 1995, more robust public education, parish meetings held across the island, concerted effort to solicit submissions. Parish meetings were held in every parish, but if you check the report, some of those meetings started over an hour late, so they were waiting for people to show up. Which speaks volumes. They received 129 submissions. The Joint Select Committee, of which I was a part, which considered their report, we invited submissions, we received 32 submissions. The 2024 Commission, that Minister Malahou Ford chaired, they received 28 submissions. That's like 1 in every 100,000 of our population. Or if you include the first generation diaspora, 1 in every 150,000. You know, we can criticize the authorities for not doing more to engage the public, but the public must also be criticized for not being sufficiently interested to engage themselves. And you know, it's not that the issues don't matter to them. Listen to the talk shows. Look at social media. They're not lacking in opinions and positions. They're not shy in expressing their concerns. But one gets the impression that having gone on Cliff Hughes or on Instagram and unburdened themselves of their grouses, their concerns, that somehow they derive some therapeutic relief, some kind of emotional satisfaction. So it's not necessary to put that in writing and send it to Minister Malahou Ford's commission, because they have unburdened themselves of their concerns. You know, it is said that a people get the government that it deserves. And I would venture to say that when the opportunity arises, it also gets the constitution that it deserves. And my final point now has to do with something that I had hoped the Constitutional Reform Commission would have addressed. I had raised it with the minister some time ago. And that is trying to untighten the Constitution belt, because in one respect it is too tight. Let me explain. Section 49 is the one that deals with how the Constitution can be amended. That section can only be altered by way of a referendum. You can't touch 49 unless you go to a referendum. Section 49 provides 3 separate levels of approval for changes to the Constitution. Simple parliamentary majority, which has been used before. Those are for sections of the Constitution that are not, considered to be all that critical to require a 2/3. The 2/3 majority, and I indicated how many sections require that 2/3. And then approval by way of a referendum. So 3 levels. The unintended difficulty that this has posed is that a 2/3 majority is not sufficient to even add to those sections that specified in Section 49, subsection 2 of 49, that require only a 2/3 majority for amendment. Let me explain it further. Both sides agree, and I think all Jamaica support, that the Electoral Commission should be entrenched. Because right now, a government, if it was crazy-minded, could go to Parliament next week and abolish election the Electoral Commission altogether. So both sides have agreed that, look, this is so important that it ought to be entrenched. Integrity Commission ought to be entrenched. But in order to entrench it, you have to amend Section 49 to include it in those sections that require a two-thirds majority to change. But in order to change 49 to include it, you have to go to the people. That is a referendum matter. And I've argued that our framers, when they were putting on the shackles and chains, perhaps went too far. And we need to address that one of two ways: either to make express provision in 49 that would allow for changes to be made that don't require a referendum. In other words, two-thirds majority in both houses of parliament. Either that, or alternatively, lift out subsection 2 altogether and create that as its own section, still retaining the requirement for the two-thirds majority. But as it is at the moment, if some time down the road, for example, one of the issues that wasn't addressed, Marlene, too, is, which is something that I think ought to be looked at, is the question of our fiscal sustainability rules. I do believe that the fiscal responsibility rules, which were brought into law during my time and have been further strengthened since my time, that those ought to have constitutional protection, and that they ought to be not something that could be altered by any government. So it would require the two-thirds. But to do that, you'd have to go amend Section 49. To amend Section 49, you have to have a referendum. We can't be going to the people every year or every 2 years when we have something that we feel ought to be protected. So that is something that I urge needs to be addressed. You know, I'm ending on a disappointing note. We have been at this business of constitutional reform now for pretty much 30 years. And I'm 76 years old now. And I really am fearful that the reform that I had hoped we would have brought to fruition don't appear likely to occur during my lifetime. And that disappoints me greatly. Thank you very much.
Thank you very much. We just had a very engaging. Is this on? You're hearing me through the mic? Yes? No? You're hearing me, but not through. I'm told it's on. Are the two mics on? They're on now. Still not? All right, let me try this again. All right, we've just heard. Had a very engaging reasoning coming from Mr. Golden. He has taken us through a journey, and it has had its meanders in various ways, you know. And we are now opening up to some discussion on it, and it's opening to questions. And I know there are a number of persons with burning questions, including the minister, who has indicated that she wishes a period during which she can make a few words and try to address a few things as they have arisen in an area for which she has portfolio responsibility. I see you, Archbishop Richards, and I see that you're burning and your hand is up and you're waiting. I see Senator Floyd Morrison and I see others. So we're going to start that in a minute, but I'm hoping in the interim we can at least get these microphones working. So Mr. Golden, are these now working? They are. Is this working now? No? All right. Let us see what we can do in the intervening period. You can probably use the handheld. Sir, so I'll take it from here then. If that's the case, I'll just moderate it from here. It's now working. Okay, thank you very much. I suspect yours is as well.
Is this one live? Yeah, this is live.
Yes. All right, so thank you. So what I'm going to do is firstly recognize Senator Lloyd Morris at the back, and the microphone will in fact be passed on to him, and we'll take some other questions as well.
Okay, thank you very much. Thank you very much, Mr. Chairman, and let me commend my
Not
friend.
hearing you.
You're not hearing?
Yes, we are.
Yeah, hearing
Okay.
you now.
Okay, all right. Let me commend my friend, former Prime Minister, for his excellent presentation, and I must say to you, PM, that I, share your pain and disappointment as one of the younger generations currently in the Parliament trying to make a difference. And when I listened to your presentation, and I wasn't able to attend the presentation from former Prime Minister Patterson, but I have subsequently listened to that on YouTube, I realized that both of you have a fundamental role to play in this consensus building effort going forward. And I think that it wouldn't be foolish to have yourself, former Prime Minister Patterson, Prime Minister Holness, the leader of the opposition, sitting down at Vale Royal or wherever, to discuss how we move forward and get consensus on some of these critical issues that are needed in terms of the constitutional reform. And I would like to get your views on that. And then, I think it was in 2018, I saw an article that you wrote about the CCJ, and the same line of argument that you posited just now in terms of the CCJ, you had outlined then. You said you wanted in that article to, get some more time to look at the issues in terms of the outcome of case. Give us some hint as to where your views are currently. And I'm wondering, if you could be a little bit more expansive as to some of those cases that you read and, the possible implications for the region. Thank you.
Difficult for me now just to recall from the top of my head specific cases. What I do recall, though, is that in several of the decisions that were handed down, the CCJ, the judges there, drew heavily on precedents from within the Commonwealth. Australia, New Zealand, Canada, Britain. So I was encouraged that they were not off on a frolic of their own, trying to apply their own unilateral wisdom, that they seem to have been part of the wider jurisprudential community, and that they were taking notes of positions that had been taken by respected courts in other parts of the Commonwealth. That's what I recall. But as I say, I'm not a legal scholar. And I'm disappointed that our legal community has not helped us to get a better understanding of the value of the court, of the quality of its decision. There's more work that they can do, man. Some of them have appeared before the CCJ. They need to help us to get a better understanding. This is not an issue that should be just left to political discussion and debate. Our legal community, our law school have to step up and help us some more.
The issue, question is about consensus, about yourself and Mr. Patterson and others.
I mean, I used to control Vale Royal, but I'm no longer in a position to invite myself there.
Good afternoon, sir. From one favorite opus incampis brother to another. You're the first person that I've actually voted for. I loved your fireside chats. I loved your inclusion in the process, as Michael Manuel talked about, walking with the people and feeling their pain. No, well, you know, there are a couple of things that are very important to Jamaicans. You know, in 100 years, all of us will not be here. We'll all have transitioned. Our legacy is a good constitution for the next generation and others to follow. Now, you were a part of the NDM, and I looked on the NDM's constitution after forming my own political movement, looking on the Marcus Garvey movement, looking on other stakeholders who would seek to change the country. And for some reason, the political elites, meaning the duopoly that we believe is the JLP, PNP, have one opinion, and the rest of Jamaicans have a different opinion on how their government should be run. For instance, we did a presentation before the Constitutional Reform Committee. And when I found out that NDM has the same kind of government structure as a Up Jamaica or a Marcus Garvey, it seems there's a big disconnect. Now, I spoke to Marlene Fort, and she could not provide any data on how this consensus has been reached regarding a directly elected president, elected Senate, which you ran on that platform as an Indian president. So I'm just curious, how is it after all these years, after much, investigations on what has not worked in this Westminster model, why is there this big change to accepting this colonial system that has not worked? You can change a mongoose in a three-piece suit is still a mongoose, my brother. This is still colonially inspired. We're not listening to the Jamaican people and what we want. We want a directly elected president. You talked about consensus, but the consensus is among the elitists in the political system. We need participation by the Jamaican people in all aspects of our lives. And right now, we're not getting that. We have more government and less impact on our lives. The potholes are still there. Many, they gave themselves a raise. Lots of Jamaicans don't have water, and they give themselves a raise without consultation or getting consensus from the very people who put them there. So I'd love you to respond to that, especially to the Indian part, where you actually accepted a directly elected president, directly elected Senate. All the problems of appointments that we're having right now, you wouldn't have that if you give that vote to the people. You wouldn't have that. Thank you for your response.
No, I don't think you're not entirely correct. I once was in favor of separation of powers. That would have involved an executive president. I've never supported election of senators. When I returned to the Jamaica Labour Party in 2002, there were some negotiations that preceded it. No? That's when, for example, Mr. Seaga embraced this idea of really supported this idea of impeachment. But in those negotiations, we had a long talk about the separation of powers idea. And he put some thoughts on the table. He says, all right, so you have a separation of powers. You elect a president who is from the JLP. You elect a parliament that is controlled by the JLP. How much separation you have? And that's when he persuaded me that, look, it is better for us to put in the Constitution safeguards that will limit the power of the Prime Minister, of the government, regardless of what kind of majority they have. So that anybody, whether your majority is overwhelming or whether your majority is slender, you are subject to certain restrictions and certain requirements in terms of accountability. The last elections we had were in 2020. It was a landslide for the JLP. Suppose that those elections we had elected a president, and we had elected a Senate, and we had elected a House of Representatives. You know where we would be now? Where is that two-thirds? Where is that two-thirds in the Senate that would prevent that government from just behaving like a tyrant?
That it will be a president from the JLP or PNP. We're asking for a directly elected president by the entire Jamaican population.
Let's get real. Let's get real.
I'm
There's
real.
nobody that can be elected to no position without a political organization behind them.
I understand that, but
Let's get real.
but it should also
Any notion that somebody can get up and will be so appealing to the people of Jamaica that he don't need no political machinery behind him. He don't need no resources to mount a effective campaign. He will just be elected because the people love him. Well,
Mr. Golden, I was part of...
Maybe Usain Bolt, but I can't think of anybody else.
I was part of NIA. And one of the things I recommend to Dr. Monroe is that we have public debates funded by the Jamaican people.
Number of persons who have some questions.
Okay, sir.
And we could take this forever. Monsignor, and then I'll get to you, Minister. A few more before you. Yes.
Can I just say one other thing that I had forgotten to say? My observation of politics in the United States over the last 8 years has reaffirmed in my mind that any business about separation of powers and an elected president is dangerous stuff. The kind of things that Donald Trump has done and said on a political platform. I give thanks for Jamaica. No political leader in Jamaica could ever do that and get away with it. None.
So two of the points that you made that resonated is the fact that there's need for consensus, and I suppose we need to put into place the parameters, the structure so as to enable such consensus to be arrived at. But the other, what I must do, come over here? Oh, sorry. But you made another point, which I think since the constitutional reform process has begun, it has been raised, but I don't think it has been addressed and expanded on. And even in your own presentation, I don't think it was expanded on. You mentioned that constitutional reform is just about moving from the Queen. It's not about moving from the monarchy as sovereign over Jamaica. But we need to bring to our people a rationale, a philosophy, a guidance with respect to what is that could include them to participate in the process. And I've been advocating from the beginning two signal moments in the life of our nation: emancipation and independence. Emancipation was about the dignity, realizing and safeguarding the dignity of our people. And I think that is fundamental to constitutional reform, because about promoting the welfare of our people presently and welfare for the generations to come after us. And that is a signal point that needs to be to become a rationale that give people an understanding that I must be part of the process. The other signal moment is our independence, about self-governance, that we have the capacity to determine the path forward as a people and as a nation. And I think that we need to reflect and expand on those two signal moments in our life as a nation to give our people the reason for participation and involvement in this process. Otherwise, what we're going to be doing is replacing the monarchy in the UK with a local monarchy that is established in the parliament. That's a perspective that I have. And why I mentioned these two signal moments is because when we speak about the social challenges and the difficulties that we are having in our people, especially in the inner city, etc., or when we have migration, it's about, we talk about the fact that persons don't respect themselves, there's no loyalty to country, etc. And so unless we have a sensitization, or orientation, a teaching of allowing persons to ground themselves in self-realization, that we have the capacity to advance ourselves as a people, as a nation, and that we are about the welfare and the dignity of every citizen of Jamaica. So I must live for my neighbor. I must live for this nation. I must live to safeguard the civilization within which I exist. And I think that, I don't know if it's too arduous for us to engage, or it's going to take too much work, but I think that is so seminal with respect to advancing this process, and especially to get down to the persons who are on the margins of this exercise now, that they think it's for the elite, as our brother said. Only the elite are participating, there's the legal minds, etc. How do we get at the grassroots people understand that, no, it matters to me, because about my welfare, the welfare of my neighbor, and the welfare of the generations to come after me.
Well, you know, Bishop, I mean, that's part of my anguish, you know. Part of my anguish. If, for example, any of us were to arrange to have a meeting in a schoolroom somewhere because we're going to discuss constitutional reform, how many people do you think are going to turn up? That's part of my anguish, right? Some intellectuals might. Some persons who, you know, have kind of studied this thing and have strong views might. I don't know what was Marlene's experience at the Emancipation Park, where she had a session recently. But we have failed somewhere, right? We have failed somewhere. I remember when just around the time of independence, I was 14 going 15. And my father took me to the National Stadium where the Union Jack came down and the Jamaican flag was raised. And I had goosebumps coming all over me. Because Ronnie will confirm it. We were at George's together. He was a couple of years ahead of me. But we were of the view at that time that our role, our mission, was to change Jamaica. That was why we were being given a secondary education. Our job was, when I left St. George's and went to Jamaica College, during lunchtime, we didn't loaf around. We gathered under the ficus tree. And we had some serious discussions because we were concerned about what was happening in South Africa. The Black Power movement was on the street struggling in America. We're having serious discussions about these things. We never have any vibes cartel to mess up our mind. I don't know what it is going to take for us to engage our young people. And the opportunities for engagement are so much greater now. Look at social media, right? In those days, we had to talk to one another. Most of us never have a telephone. So it's something that I'm worried about. The other issue that you raise is that we must not overlook one important thing, The Governor General in Jamaica, who hopefully will be replaced by the President of Jamaica, has more authority and power in relation to Jamaica than King Charles has in relation to the United Kingdom. We have created a hybrid, and we have done that through consensus, starting with the Electoral Advisory Committee back in 1979, where we have vested in the Governor General certain critical authority. So the Electoral Commission consists of 2 members that the PNP appoint, 2 members that the JLP appoint, and is it 3 or 4 members the Governor General appoints. That's where that critical balance rests. And that's why you have the people of the kind of integrity that sit there. Same thing with the Broadcasting Commission, same thing with the Contractor General. So our Governor General is not a ceremonial figure. I refer to him as a quasi-executive role. And in time to come, we are going to have to ensure, which is why the question of how the president is to be appointed is so critical. We have been lucky so far that our governors general have handled that position with the kind of integrity that we would want. But that's why the method of appointing the president is so critical. You don't want to have somebody in there who is basically a representative of the party in power. It has to be a symbol of unity that can be relied on. When you're appointing members to the Electoral Commission, make sure you appoint people who you know will bring a certain quality of judgment and integrity to the process. That's what you want. And in the proposals that were made here, we are seeking to vest greater authority in him, in that person, him or she. For example, in the appointment of the Chief Justice, the President of the Court of Appeal, and various things like that. So that's why that's something that we have to look at very carefully. And that's why I have trouble with the method that the Commission has proposed for breaking a deadlock. Because that method is almost to ensure that a deadlock is going to become a strategy that is used.
I'm not here to cause mischief, so you don't need to look at me funny. I have a question that, for me, in what you have shared with us today, comes loudly to me. Because in all this talk about consensus, and in all this talk about how we engage the people and how the people become engaged in the process, is the issue of the tribal nature of the politics that we have enhanced over the years. In my 4th year now in service in the Senate, it has become apparent to me that what I thought was a feature of your generation, Daddy, is not just a feature of your generation, but also a feature of mine. And I can't understand in a lot of circumstances why my generation and generations younger than me are as tribal as they are, because I deem that tribal element to have arisen from the political divisions of the 1970s. I could be wrong. So my question to you is, how are we going to encourage our people to become engaged in constitutional reform? How do we engage them in constitutional reform without addressing the tribalism with which, and the partisanship with which we engage issues that are national issues and issues that affect all of us, no matter what political party we come from. If I try to have a conversation, for argument's sake, with a group of young people, the first thing they hit me with is the fact that I'm a government Labour Party senator. They are almost not willing to hear a view. I have to work really hard to persuade them to sit down to have an objective discussion with me. And I have to declare that I'm not trying to recruit them. How do we get over that? Because young people don't want to talk to politicians. They're not interested in being engaged. The vast majority of them have left the room because they just hear tribal, they hear partisanship. How do we overcome that? I'm sorry my question was so long.
I'm sorry, I don't know how to answer you. Because I'm distraught myself. You know, many years ago I had a discussion. I won't call the person's name because they haven't authorized me to disclose it. But that person was a senior officer in the People's National Party. And I had a discussion. I said, you know, I don't understand. Within the Labour Party, I find that some of the older heads are more receptive to change than the youngsters. And the person said to me, same thing in the PNP. I remember when I was pushing some ideas for change within the JLP, somebody that I could rely on for support was the late Alvarez, who was older than me. And I got the impression, I hope I'm not selling them short, but some of the youngsters, I got the impression that they have dreamt for so long about getting behind the wheel, that having got behind the wheel, they're not changing the direction. Wherever the car was heading, them I go same way. But them control the wheel now. And remember what I said to you earlier? People like Randy Twist and myself we thought too much of ourselves, you know. We thought that we were sent here to change the world. That's what we thought. And we were on a mission. And quite frankly, I don't think, Randy, that we have done as well as we thought we should have done. So, Shireen, I don't know what to say. There needs to be an engagement, but I don't know if that engagement can effectively be conducted within the political framework. I think perhaps we need to start talking to the Sixth Forms Association, young people's organization, trying to see if we can engage them. And when I say we, if we can keep politicians as far from the process as possible. But I don't want to go on and go on, you know. But I'm worried about this place up here. I'm worried about the university. University has become such an economic challenge that you can't take issue with the students here, you know, when they come and what they want to do is to get a degree and to get out of here as fast as possible because them parents suffering to keep them here. So if they can get that diploma or get a work. When I was here, and that's a long time ago, I left here in 1969. When I was here, university was more than just getting a diploma and getting a work. Those were the days of, you know, George Beckford and Ken Post and them kind of man. And the reasoning that is going on here, that used to go on every day. And we had a view. I don't know that we can blame the students, but that kind of intellectual excitement doesn't seem to exist. And we need to find a way, otherwise artificial intelligence will take control of all of us.
Mr. Small, Hugh Small, and then the minister will make her intervention.
After the 1989 election, Bruce called me and asked me to come and sit with him because we were members of parliament for adjoining constituencies. He said to me that before the election, the government had a plan to save the center of Spanish Town. And he wanted me to come and look at the plans that had been developed by Moxie Morrison's firm. And he arranged for us to sit down at Terranova Hotel and explained what Spanish Town could become if we didn't address the problem of what was there in the center that needed to be preserved and how we could go about making sure that there was a new town center and an orderly plan for the development of Spanish Town. We know what Spanish Town is reputed to be now. It was a very impressive plan. And I took it to first a small group and then a larger group within the PNP executive. And I was roundly dismissed as being politically naive and told that what Bruce was trying to do was A, B, and C. And I said, well, that's not what we discussed. And here were the plans to move the courthouse out of the center of Spanish Town, to preserve the whole of the ancient buildings, and to address some of the social problems that were choking off Spanish Town. But I couldn't get a hearing. I remember when I spoke, I'm going to call her name now, I spoke to another person who had an influence in St. Catherine, Vin Edwards. Him laugh at me. He said, Comrade Small, you're a real fool, you know. But what we're trying to do was approach what was a deep social, cultural, national, historic problem that didn't only affect the center of Spanish Town, but one of the access routes into the capital city, Kingston. Shireen, I don't know how we're going to get to where you have suggested we need to go. All I know is that as I'm writing my memoirs now, I'm coming up against the stubborn and corrosive nature of partisan politics. And it didn't start in the 70s. It did not start in the 70s.
That the minister wishes to make at this time, and then we'll have you, Jeanette, afterwards. Yes.
Is this good enough? I want to begin by thanking the faculty for organizing the series. I found the first one particularly engaging, and this one even more so. Prime Minister Golden, you continue to be your very provocative self. You began by tracing the approach that has been taken, and I found it particularly important. I should like everyone to know that we are embarking on a phased approach. because the work to reform the Constitution is a lot, and it involves a lot of technicality. And everything cannot be done at the same time. The process of change has to be managed, and it has to be managed well. If change is done at a pace that is greater than the people can absorb, it will throw your society into disruptive disequilibrium. And those who have researched this and have spent a lot of time looking at it have documented cases and have repeatedly stated the case of the importance of managing change because of the absorptive capacity of the society. The government has to be administered, and it's not administered by the man in the street. You may not wish to hear that, but it is a fact. Government is administered by officials who are given functions and powers to exercise. And if you have a government where the people themselves are ignorant of their own powers and functions, or they exercise the powers and carry out their functions carelessly, you're going to have even greater problem. Admittedly, there is a weakness in the context in which this work is being done. Not only you, Prime Minister Golden, has said it, but it's been a point of constructive criticism for all who have written. The need for greater education, the gap, the knowledge gap in the society. And it's very sad that the increase in information and new and easier media of exchanging information have not resulted in an increase in knowledge. We have a population that is distracted and attracted by many things. And so the strategy of engaging, part of what Shireen has lamented, part of the difficulty that you have admitted, remains the biggest work for us. How do we meaningfully engage the people and get their attention? Because it's not even so much the effort that is being judged, but the outcome and the impact of the effort. So I thank you for clarifying the matter of our own de facto head of state being in a hybrid form that is not ceremonial. I think it's the greatest clarity that I've heard expressing it and explaining it. I myself have attempted to explain to those who continue to ask and describe our arrangement as purely ceremonial, to say it is not so. Prime Minister Pattison raised it, and I think you have improved on the clarity, and it is something that will have to be said repeatedly, again and again and again. I deem it a privilege to be given the opportunity to lead this process from where I'm leading it. And believe me, it has been the most trying work assigned to me. And I've said to Prime Minister Golden, you know, I was in another place where even the harshest critics said that I was doing well, and my own love for the law. And the Prime Minister inveigled me because of the duty, he said, was placed on him when he was elected to lead. I blame him all the time, yes. Yes. So that's why I could answer for him to say that he has to remain to be part of the process, if only because of what he brings to the table, and continue to do so. But we decided as a matter of policy to honor the work that went before us. And it's important for all of you who have been part of work, including you, Reverend Thwaites, that your efforts be honored. even when they fall short of accomplishing the goal. So we recognize that so much work had been done by the Constitutional Reform Committee, the Joint Select Committee on Constitutional and Electoral Reform, coupled with the fact that the provisions of the Constitution that we're seeking to change in the first phase, the deeply entrenched provisions, have not changed since the Constitution came into effect. Now, you can argue what you want to argue, but that is an uncontradicted fact. It's the same set of deeply entrenched provisions that we're dealing with today that we inherited when the Constitution came into effect, because we have not had a referendum in independent Jamaica. None of those provisions has been changed, because the process to change them requires the ultimate approval of the people. A lot of recommendations have been made, a lot of talk has been done, but we have fallen short of making those changes. And so, it would make no sense to start afresh when you're dealing with the same set of provisions, when the research shows the extent of the work that was done. But wisdom tells you that when you have an implementation deficit, you really need to assess whether the assumptions made then continue to hold today. And that is why the process was deliberately twofold: honoring the work done before, but seeking to refresh, if need be, the recommendations to see if the consensus that was arrived at then remains today, if greater consensus needs to be built, or if changes need to be made. And it's important that people understand that regardless of where you stand on any of the issues. You can disagree with the approach, but I want you to understand that it was carefully thought out. Carefully thought out. So when you disagree, I ask you, suggest something better, because my own approach is always to be persuaded by a better approach and better perspective. So the president, the appointment process, I have taken keen interest, and I believe all members of the CRC have taken keen interest in the feedback that we have received on the recommendation to break a deadlock. The process to appoint the president is twofold. The first is a nomination, and the second is a confirmation. And the nomination process involves work between a prime minister and a leader of the opposition, and confirmation by the parliament. In making the second limb of the recommendation, it was to address the real likelihood of the deadlock. And we looked in Trinidad, where a system existed until it didn't work, consensus between prime minister and leader of the opposition. And when we looked at other jurisdictions, we deliberated on what could be a process to ensure that you do not remain in deadlock. But I think the point about simple majority incentivizing a lack of consensus is one that has to be taken seriously. So every considered view that is shared on the recommendation, we are listening to it. There is no monopoly. I think we are all trying to do it well and do it better. It's not going to be perfect. But be assured that for all of the views that have been expressed, we're paying close attention to. So that's not the end of it. The impeachment matter, again, is one where, speaking for myself, I recognize and I share the concern for finding a mechanism that is workable, practical, devoid of the kind of spectacle that we are prone to gravitate towards, to hold our officials to account in a meaningful way. So that door is not closed at all. I said it in the park, Jeanette, when we had the sidebar before and when you raised it at the podium. And I think already in the recommendations for the office of president is a process. And so we may have to look at whether that process can be extended to the other elected officials. And you're right, Prime Minister Golding, our constitutional system already has a holding to account. And what we want is to ensure that the process is practical and that it yields the result that we're seeking. Having said that, I recognize that process is also as important as outcome. And you may not get an outcome, but going through a process may be important. So a process of a trial, for example, where there are allegations that a crime has been committed is important before you get to a verdict of guilty or not guilty. Because at the end of the day, someone may say the person is guilty. But when you go through the process of a trial, and you have to meet the standard of proof beyond reasonable doubt, and who bears the burden of proof, you may come out with a different outcome. And people will agree to disagree with the outcome, but feel satisfied that the process was one of integrity. So I don't know what my learned friend, the Reverend, is shaking his head at, but I look forward to hearing it. Process sometimes is as important as outcome, but process must be practical and meaningful and not just embarked upon for the sake of a spectacle or satisfying an appetite. The other matter has to do with fixed election dates, and you sought some clarity on the recommendation. So the life of the Parliament is fixed at an outer life unless sooner dissolved, which is what allows for elections to be called earlier. So we looked at taking out the provision about a sooner dissolving of the Parliament and have it fixed at the 5 years, and then providing a period of 3 months thereafter within which the elections are to be called, instead of a fixed election date as what occurs, for example, in the US, which says on the second Tuesday or whatever it is of second Tuesday in November. Right, and we gave a rationale about the inflexibility in a small jurisdiction. But I take the point that it requires some clarity. The recommendation about consensus is because the life of the Parliament is a deeply entrenched provision. So you can have fixed election date legislated other than in the Constitution. But if we're going to go to fix the life of the Parliament, it would be an amendment to the deeply entrenched provision, which sets the outer life as 5 years with a proviso for a sooner dissolution of the Parliament. On the matter of the sensitive appointments, and in particular to the judicial office, we're of the view that the matter of the judicial branch of government is so substantial that it's going to require almost focused attention without the distraction of the other two branches of government. And also because we began with rationalizing the approach in accordance with the process for amending the Constitution, focusing first on the deeply entrenched provisions. And you should note early the indication that the process will require the holding of more than one referendum if we're going to achieve the goal. So I think your framing of the issue around the final court and how it will either close the door or provide passage is one of the most useful expose that I've heard recently, acknowledging the merits of both sides, as I know you are prone to do. But I was particularly helped by the points you made about the need for critical assessment and the approach taken so far being unhelpful, really unhelpful. I thought I should point out that the right of appeal to the Privy Council that is now in the Constitution has to be looked at in the context of the King being head of state and the 1833 Judicial Committee Act has to be looked at in that context. So the question is not whether we have a right that we can enforce in the Constitution, but what will happen to it when the king is no longer head of state. That is really how it will have to be assessed, because of the link between the king as head of state, the availability of institutions by virtue of that headship, and when the change is made, what will happen. So to my mind, some of the things that appear unclear will become clearer once that change is made. Because if some things rest on a foundation that will no longer be there, then they will go.
Trinidad and Dominica seem to have worked it out.
When Trinidad transitioned, the CCJ was not in existence. So I have found a reference to the Trinidadian example as going to a certain point and no further. Yes, it does provide precedent that you can continue to have, you can continue in a relationship with the Privy Council without having the king as head of state, but you have to bear in mind when that was done. There are so many other issues, ladies and gentlemen, that we have to pursue. I do not share the pessimism of my former Prime Minister, the note on which he ended. I don't share it at all. We are still a young country.
You see, you're not 76 years old.
What he has done is made the case convincingly for another approach to be taken. And for all who say that, so much more needs to be done, we know that. And don't for one moment think that we're not working on it. My learned friend, Mr. Small, who sits on the committee, will tell you that one of the concerns that we have been addressing, though not as frontally yet, is how much can we realistically get done at this stage of the life of the Parliament, when you require collaboration, but you're prone to competing. Is something that we will have to look at, and we have to balance it against whether we waste the time. Waste may not be the appropriate word, but we have to use every bit of the life of Parliament to get this work done. It is way too important. So, Prime Minister, you didn't address the first imperative that we are pursuing in this phase of the reform, and that is putting the Constitution of Jamaica in proper form. What we have dubbed the Jamaicanization of the Constitution. Some say it is only the lawyers who are preoccupied with the issue of the inferior, inappropriate form in which our highest law exists. In order to make that change and put the Constitution in its rightful, proper form, the change will have to be approved by the people. And so, even while the work remains on the many other issues in the transition to a republic, bear in mind that it is not empty symbolism to have your highest law passed by your Parliament that is empowered to pass laws for the peace, order, and good government of your country, and that law approved by the people. So the two goals in the first phase is having the Constitution put in proper form, passed by the people, passed by the Parliament, approved by the people. Need a referendum for that. And secondly, abolishing the monarch and the constitutional monarchy as our form of government. I've said repeatedly that where we get off the constitutional monarchy road need not be where we end on the republic road. I know we want it all, but we may not be able to do it all at once. And it is my hope that with all the distraction and in spite of our political differences, that we will create some space to be guided. Because the truth is that a lot who have spoken inaccurately. And I'm not even talking about interpretation of provisions now. I'm talking about even quoting provisions of the Constitution and other laws. So you don't have to be trained in law to accurately state a provision of the law. You only need to be able to read, to just state it. And I continue to be amazed at how many inaccurately state it. And there are many who are wrong. This is not a matter of views now, and are strong in it. You know, in law they tell you that a mistaken witness can be a convincing witness, depending on the approach you take. Let us not seek to convince in our wrongness or in our mistaken belief, but let us all keep an open mind. I want to end by asking, how many of you in this room have read the report of the committee and read it in full? Still a handful. And it is not because it's not made available. So that tells you, even those who are showing up with an interest still have some work to do. I renew my commitment to ensuring that even in the face of disagreement, that we will make progress on the reform of our Constitution. We must do it. We cannot afford to raise it again and let it fall flat. That is when, Prime Minister Golding, you'd be turning over perhaps like a revolver. Half a loaf sometimes is better than no loaf at all. Let's continue to make progress. Thank you.
Intervention. We'll ask Jeanette Calder to make her contribution. Dr. Jackson, you have something as well to say? I'll take you after Jeanette Calder.
Thank you, Moderator Malcolm, former Prime Minister Golding. Minister, good afternoon, everyone. Moderator, I really felt that the contribution of the minister felt like a really good wrap-up, and so I was actually going to forego my question. But if you are going to take another, I'll just quickly say, I want to really thank Mr. Golding for how he framed his lecture today. And there's so much he could have said, and there's so much to digest, but the idea of framing it around the spirit with which we need to approach the process, I think is very, very important, and that's the spirit of consensus. Approaching it by working together and determining that we have to be intentional about what we want for the Jamaican people, and that though we have been discussing this for 30 years, it is the time now for us to move beyond it and achieve something for constitutional reform. So I really want to thank you for that, as well as for your comments on accountability. I can bypass my question because I think you addressed it so well. But there is a report, I'm not so sure you're familiar with Prime Minister Golding. It's called the POP study. In the 2021 report, they looked at the political culture of democracy in Jamaica and in the Americas. The subtitle is Taking the Pulse of Democracy. I don't know if you're familiar with it.
Whose report was that?
Vanderbilt University. They do it every 2 years. So I wanted to ask you in the context of the Constitution, because Taking the Pulse of Democracy is looking at that. There were just 3 things that they said about Jamaica that I wanted to solicit your comments on. They indicated that there was a question, do you believe that when a country is facing very difficult times, that it is justifiable for the Prime Minister or the President of the country to govern without the Parliament?
Should do what?
To govern without the Parliament. And to my surprise, 44% of Jamaicans, we led the survey in indicating that, yes, we would be comfortable in bypassing the Parliament if the country was facing a particular difficult time. It also asked if we would be willing to have a military coup to deal with the problem of corruption. And we were number 3 out of 34 countries where 46% of us would have been happy to have a military coup. And last, they asked the question if we had a strong leader to bend the rules if it was necessary, if Jamaicans would be inclined to forego our legal framework to facilitate progress, and 55% of Jamaicans said yes. So I wanted to ask you, in the context of Jamaicans feeling this way about our institutions and being willing to bypass them, this is a threat to our democracy. Would you like to comment on it in the context of the discussion we're having today and the concerns that you have for the young people and the direction we're going in?
Well, I've already expressed my concern at the sort of mental state of many of our people on many of these issues. I'm a little wary, though, Janet, I will tell you, I'm a little wary about polls that are done and numbers that are produced, because a lot depends on how the poll was carried out. Was it a random sample? Were the questions designed to elicit a particular response? I'm worried about that. But I'm not questioning the integrity of the polls. I've never done that. It's just that I treat them with some caution. We do have, well, I can't put it any better than I expressed it when I was at the podium, you know. A country gets the government it deserves. And when the opportunity arises, it gets the constitution it deserves. And therefore, my daughter-in-law is here, my grandchildren who are going to have to deal with it. I won't be here. It is they who are going to have to contend with the decisions that are made by the generation that is now in charge, right? I can only urge you. I mean, you and I have had several conversations, though, and you know the regard I have for you and the work that you do. People like you and organizations like yours, the Archbishop is sitting beside you. You just have to keep at it, no? Try and see if we can engage people beyond just the material and beyond just the latest craze. And the opportunity to do that is so abundant now. I mean, look at what social media could do. I mean, my daughter-in-law, for example, she has a program, Youth, what? Yeah, Talk Up Youth, that has engaged young people to discuss some serious things. So they're not all dancehall crazy people, you know. It's just that the approach to getting them engaged, to hearing their views, and trying to guide those views, because some of those views are kind of weird. But that is something that has to be pursued in a structured way. I've been out of government for a long time, so I didn't know, for example, what kind of program the Social Development Commission has going. But we have to use every agency that we have, every tool, whether it is government, civil society, we have to try to engage them. Because ultimately, I mean, they're the ones who are going to be in charge. They're the ones who are going to be taking the decisions. Decisions not only about their own lives, but about the lives of other people. And therefore, we have to find a way to get them involved and perhaps to disabuse their minds of some of the crazy things that they may have told Vanderbilt.
Okay. Fine. 1 minute. Okay, we're going to take one final question from Dr. Jackson. Reverend Thwaites, you had a question? No, well, I think Dr. Jackson will permit you.
Thank you, Mr. Chairman. I really wanted to say that Bruce Golding has not been given sufficient credit for advancing and seeing to the enactment of the Charter of Fundamental Rights. He was the one who pushed it, and in the way that he described, and much more. That is the fundamental issue, the hub of the concern of the people of Jamaica. King Charles can stay where he is. A lot of this discussion has been about mechanisms and forms. The outcome that the people of Jamaica want, the supreme outcome, is to ensure the inviolable rights of themselves as individuals and their brothers and sisters. The Fundamental Rights Charter takes us in that direction further than we have ever been, and encapsulates the philosophy of the change of the philosophy of constitutional order, which Archbishop Richard spoke about. And it is all well and good for us to say that differing views are being taken into account, but with what change? Is the reform report that is before the country now, is it going to be influenced by all of these different views that are being taken into account? Or are we being educated to agree with what they have decided? Chairman Bruce, consensus has a fundamental ingredient. It is trust. And trust is what is lacking right now.
I'm so happy that man.
Before you come in, you know, I agree with you. I made some comments when PJ was here the last time to indicate that. And I wondered, the relationship that I have with him now, I didn't have it when we were both in the house. What makes the difference? Because we're not cussing each other anymore? Somehow, but as I said before, if Michael Manley and Edward Seaga can reach an accord on anything, then Archbishop, Jesus and the devil could do it too. I mean, one other thing, Roddy, before you come in. And I keep referring to Mr. Seaga because he played such a significant role in shaping the Charter of Rights. One of the things that he had advocated, and we haven't done it, Marley, is something that we need to look at. He wanted the Charter of Rights, perhaps not in the language that it is now in the Constitution, but he wanted it to be simplified and put out in a booklet that every Jamaican, if he wanted, can walk around with it in the back pocket. And if a policeman stop him and try to rough him up, he can drag it out and say, listen, no, you see this thing here? You see section so and so, don't mess with me. We haven't done that. And I really believe it's always something that we distribute freely in schools, that people can say, well, here are my rights. These are the rights that my Constitution guarantees me.
Of importance to achieve what Shireen asked about is the insertion of civic education in our schools. 650,000 Jamaicans go to school. Jamaica is blessed that we have a place in school for every child from age 3 to age 13. And we have done insufficiently to educate people in citizenship, in love of nation. That is an important portal for us. And finally, I express my own disappointment. How must we trust the Constitutional Reform Committee, which does not publish the statements of every member, the verbatim notes of its process, and the full minutes of its proceedings? On what basis does that engender trust, please? Wheel and come again. Who chose the members of that committee? Are they really representative? These are the things that make the difference. And these will govern whether we adhere to whatever referendum comes. But please, align the views of those who feel that they have the authority because they were elected to determine how the Constitution changes phase. Please understand that they don't have that right. They have the right to execute what the people want. And approaching the people, even in some of the comments here, as if it is some purblindness on our part, and that we must eventually come and understand and agree with them, is absolutely wrong-footed, and it's immoral.
Yes. Yes, it's my honor that my lecturer, when I was here, has said everything basically that I would want to say. It is all about empowerment. Yes. You know, it is about empowerment. Our people suffer from the lack of empowerment. And where does it come from? It comes from our history. Our history, we have to teach our education and our civics and our history have to teach what we have undergone. And I am going to make two examples. There are two examples I'm going to point out. And I don't really engage in discussion because in my yearbook, graduating from Wolmer's, my classmates wrote under my picture, he disrupts class in discussions by the words, well, I think. The fact of the matter is, you will remember that there was a situation where these school children were wearing a jersey, some sort of jersey that had the word dunce on it, fully dunce. And what did they do? They locked them out of school. They ran them out of things and went. That was a perfect opportunity to bring them together and say, okay, let us discuss this and let us come up with a code of dress. And you know what will happen? They will feel, because there must be a psychological reason why they feel that they need to go and pick up this thing and wear this thing that we don't understand as older people. We just have no clue. But what you have to do is to reach them where they are and give them the power. Give them the power, guided power. And this is the problem in Jamaica. And I finally, because this made me, and I'm confessing that I cried. I picked up the Sunday paper and I saw a headline that court awards 44 million to wrongfully arrested man. And I read it and I reached a point where they said that Justice Mason did not compensate Robinson for the inhumane and undignified condition he endured in the lockups at the Constant Springs station. Robinson, in referring to the inhumane conditions at the Constant Spring police station, testified that he had to share a small cell with 13 other persons. He said he had to fold, and I've been there, and I've been to several, and it's not 12 by 12, and you're talking about 13 other men that he never met before, all right? And other persons. He said he had to they had to fold themselves up on the gritty and asphalt-like ground in a line in order to sleep. They slept on cardboard or newspaper or whatever was available. He spoke of the cell having no bathroom facilities, and he and the others in the cell had to urinate in plastic bottles and defecate in scandal bags in the presence of cellmates because they were only allowed to use the bathroom once per day. He described the bathroom, communal bathroom, as filthy and lacking in privacy for persons showering or using the toilet. The meals, he said, were improperly cooked, causing him nausea, and were served from dirty buckets and paint pans. Now, when this is the Gleaner, the Sunday Gleaner. No, it is the editorial Gleaner. Editorial, it says at the bottom it says editorial. Oh, the writer, Barbara Gale. On the case that was just, and this is Sunday, July 28th. Now, when I saw that, I am seeing the picture of our ancestors being brought over in these ships and so on. And I've always wondered, how do they defecate? How do they urinate? How do they sleep? How do they eat? And it bothers me so much. I want to go to Africa, but I don't think I can emotionally think. And when I read this is exactly the same thing. But what bothered me was that this was our response, because it is us. It's not just the judge, it's us, our response. The judge referred to the fact that the judge, however, ruled that the detention of the claimant, quote, was no less than what would be expected of a Jamaican holding area for detainees and others. Now, it seemed to me that just coming back. All I'm saying to you is that what we have to start looking at is our psychosocial conditioning. And that is where we have to reach. And by our example, and we have to reach, because this is the effect that it has on the populace. That's why they are disengaged and they get into all these subgroups. All right? So it's about empowerment and shared value. All right? And this is my view in relation to this.
To respond to something that the Reverend Thwaites had said. 30 seconds.
I thought it important to respond to a point that Reverend Thwaites made. We can agree to disagree, and that doesn't mean it's a bad thing. And I'm trying not to respond with the emotions that were evoked when you spoke, because it came across not so well for me, just listening to what was said. But just to say that the fact that someone is elected put you in a position to do something. I think it would be a miseducation of the young people here to dismiss that fact in a democracy, because we are elected in a representative capacity, and whether one chooses to carry out the functions well or not does not take away from the responsibility that comes with the office. So it's not true to say that you have no power to do anything. It doesn't matter what we talk about laws. There is a process by which law is made and changed formally. You may criticize it along any other, but we don't make statute law in the public square. If we truly honor constitutional supremacy, we will honor what comes with it. So, however contrary your views may be to the ones expressed, because I heard the song beneath the music, of the scorn you poured on what was said. It's important that we are accurate in what we convey when we have a medium to share, because people are going to read and listen and act on what we say. So, ladies and gentlemen, it doesn't matter how low your trust is in the democracy. The freely, periodically elected legislature is the foundation of the democracy. And a lot comes with that. So we may be dissatisfied with how it is practiced, but not for one moment should we throw the baby out with the bathwater. And we have to be a lot more discerning and accurate when we speak.
Thank you, Minister. I'm here for this. Now, we have had a long afternoon running into early evening almost. And part of what we have done in this discussion, I know there's a slight feedback, discussion as much as with the last and with the other events we have had, is that we have tried not to curtail the discussion too much. there is a process of ventilation in these reasonings that we've been hoping for, and we got a lot of that today as well. And we're hoping that this continues. Mr. Golding has been more than patient. He spoke and he poured out and he discussed and he gave great ideas. I was myself very satisfied with a lot of what I heard and made my own notes of things that were said. And I'm sure as we move forward in this process, we're all going to be the beneficiaries, the greater beneficiaries of the process that has been engaged. Nothing of this nature happens, of course, without the kind support of many persons and the hard work of persons we do not always see. And we want to, just in a quick vote of thanks, if I may, thank firstly the principal, Denzel Williams, here at UWI-Mona, who has wholeheartedly been in support and who continues to support in that vein of public advocacy that he asks us to support. Marjorie Henry from the faculty here, and Arlene Supersad, who everybody knows by now, and Odisha Coates rather, and the entire faculty team for the hard work they do, Mrs. Kelly and everybody else. We thank them. The Mona Institute, the Mona IT persons, Mona TV, everybody. And of course, we go to the media, and the media houses are very well represented here. Our security, marketing. We thank, of course, some of our sponsors, to include CPJ. You would have seen something outside. The Derrimon Trading Group, who have also been supportive. And the minister, through her own ministry, have always been very supportive. They're always here and supportive. And of course, above all, we thank everyone here online for your support and for your patience. We know you have been patient. We know you have listened longer than you anticipated. But rest assured, the views that you have shared with us are being recorded, and we intend to make very valuable use of all of it. It's part of what we're doing. And we thank you for that effort, continuing. And what we do know is that there's a greater number even online than we have here, much greater. And we know that the online event will be posted. So it will continue to get views well after today. So again, thank you, thank marketing, thank everybody. And again, thank you and have a wonderful evening. Share with others, share with the experiences, but more than all, think about them. Don't get trapped into the tunnels wherever they may be, but think of how we can be expansive in our thinking and how we can take new ideas on board. I know the minister is listening, and she too has already said that new ideas, when they come on board, will be entertained. So we're hopeful for that to happen. Thanks again, and have a wonderful evening.